So, ladies and gentlemen, I think we are going to start. Welcome to the panel organized by the Council of Europe. I wanted to start with some personal announcement. Unfortunately, I'm not Patrick Penninckx, as you could see. So he didn't make it this time to CPDP, unfortunately. So you have to bear with me. I'm moderating this excellent panel we have prepared for you. I also wish to thank the organizers for having us here, having this privileged room and moment here on speaking on issues which are really dear to us. So thank you. CPDP is an event that Council of Europe always supported and will do for the future, I'm sure. When it comes to Council of Europe, for those who are not familiar with the organization, and really in a nutshell, and just to leave a little bit more time for the speakers to warm up, but Council of Europe is an organization that used to have 47 member states. Now we have 46 member states covering continental Europe and having more than 230 conventions. Some of them are open, therefore third countries that non-member states of the Council of Europe can join to it, such as the case for the Data Protection Convention. Council of Europe has a main preoccupation today, as you might have heard or you know, the war against Ukraine, which I really hope will end before 2024. In this space, I also wanted to share with you one of the latest news from our organization, which was a summit that has been organized for the 4th time in the whole history of our organization, gathering heads of state and governments, reaffirming their commitments to democracy, rule of law, and protection of human rights. They also set up a register to document war crimes, which would serve the compensation for war crime victims. I also wanted to use this opportunity very quickly to shout out to the Ukrainian government. I don't know if they are represented here, but they are in this very difficult moment still continue working on the data protection legislation, which is a really, really great deal. So thank you very much, and wanted to once more confirm that they can count, you can count on Council of Europe support in that. Closing to or approaching to our to the purpose and the topic of the panel. So what will change in 2024? When it comes to our instrument that I briefly referred to, the Open Convention on Data Protection and Protection of Privacy, which we call Convention 108, as we give numbers to our conventions. So this is the Convention 108, which has recently been modified and amended by a protocol that was adopted in 2018, which will really, we believe, contribute to the protection of human dignity in the digital age, while also facilitating the free flow of data between countries and globally for the benefit of democratic systems, interconnected and increasingly digital societies, and inclusive economic growth of our countries and globally. It has today 55 parties and 36 observers. So next time we will have our plenary meeting, we're expecting 120 guests coming from several parts of the world. So we are discussing global issues or issues of global relevance that are also can have an impact on the future and on the future of the protection of privacy. And now I turn really to the purpose of the panel, so what will change in 2024. So we wanted this Council of Europe and Data Protection Union use this opportunity to announce that we have high hopes and real probability that Convention 108 plus, the modernized convention, will enter into force in 2024. So this is a big deal for us, of course. We have been working on this a lot. It will require additional work from us for many aspects of it. But we have invited today for you 4 wonderful speakers that can give their views and their opinions on what will change for them, for their institutions. Would that have an impact on global trends? What expectations should we set regarding this? What are the areas of high importance the public also should be aware of, if there is any? So with this little introduction, I turn to the first part of the panel, which will allow speakers to speak and introduce themselves, a little bit the area they are working and their relation to this Convention 108 Plus, this instrument, and the future, what we'll bring for them. And we will start with Tamar Kaldani. Tamar Kaldani she's the vice chair, so she has been the vice chair of the consultative committee of the Council of Europe of this convention, as I mentioned, Convention 108. But she's now a senior data protection expert for the Council of Europe, of course, for the European Union, the GIS, the German Development Agency, United Nations, and the OSCE. Tamar contributes to the development of data protection, legal frameworks, and independent supervisory authorities in Africa and Central Asia. Tamar served as the first data protection commissioner of Georgia from 2013 to 2018. Tamar, the floor is yours.
Thank you so much, Peter. I'm very delighted to be part of this panel. What will change in 2024? €1 million question, right? Indeed, we all hope that modernized Convention 108 Plus will change a lot because we see it as a global tool for regulatory convergence. Convention is open instrument, not only Council of Europe member states, but other states can be invited to join and accede to the convention. And Peter already described that there are 55 parties to the current convention, landmarking instrument with a global relevance that inspired development of many regional and national data protection legal frameworks. And then Convention 108 Plus is also a global tool for me because it sets commonly acceptable principles and rights that should ensure protection of the right to privacy is an internationally recognized fundamental human right. And therefore, there is a need to make sure that this fundamental human right is protected and safeguarded no matter where we are, in which jurisdiction. That's why I believe that this is very important to support speedy accession to the convention of all parties. Right now there are 24 states that have already signed and ratified convention. There are 21 signatures not yet followed by ratification, and I think that this is this should be one of the main priority for us in 2023 to make sure that by 2024 convention is fully enforced and applicable. And besides these common acceptable principles such as transparency, accountability, privacy by design, stronger safeguards for individuals, convention also has important components such as transborder data flows, which is very relevant for many jurisdictions. And then what is also important, then the Convention Committee will gain new capacity and role. It won't be only consultative committee, but it will have an opportunity through its monitoring and follow-up mechanism to make sure that all parties fulfill their obligations and with their national legal frameworks ensure consistency with the principles and safeguards provided by Convention 108 Plus. And it also provides more opportunities for supervisory authorities to collaborate and discuss and define future strategy. And obviously this is very important part, guidelines that committee was providing. It should be further strengthened and reinforced, because guidelines of the committee serve as a point of reference in many jurisdictions, including in the jurisdictions where I work in Africa or Central Asia. The guidelines developed by EDPB and guidelines developed by the committee are the first and instrumental tools for many newly established authorities to use, that they use to provide, to contextualize and provide the guidelines that will be applicable in particular jurisdictions. Again, transborder data flows and opportunity that convention provides to the members and parties is also very instrumental, and the interest towards this scheme and framework is huge. And this is one of the important motivators for those observers who regularly participate in the work of the committee, and the jurisdictions are also interested to join, at least as an observer right now. Even if when the convention, modernized convention, is not in force yet, the interest is huge. We recently, with Peter, we had an opportunity to engage, for example, with the delegation from Kazakhstan. Kenya also already confirmed its interest to join, and there are preparatory stages to join as an observer, the committee, and closely observe developments with regard to Convention 108 plus, and obviously with full enactment of the convention, more interest will be there. I'm absolutely sure. So these are my initial, let's say, remarks, and happy to continue after.
Thank you. Thank you so much, Tamar. Now I'm turning to Bruno Giancarelli from European Commission. Bruno.
Yes, first, good morning, everybody. So you asked me, what is the relevance of Convention 108 for the EU? Essential, I would say. For the EU data protection framework, Convention 108, if I can summarize it like that, is an important part of our past, present, and future. Important part of the past, of the roots of EU data protection rules, because as you know, as you will remember, both first the 1995 directive and then the GDPR have their roots precisely, are based on the principles first developed by Convention 108. But that doesn't stop there. As Tamar, you have just recalled, Convention 108 is just not a, if I may say so, a nice treaty that you sign, ratify, and then frame in your Ministry of Foreign Affairs. It's a living instrument. Through the work of its committee and of other governance bodies, which is, it's important to recall it, it's the only international standard-setting body in the area of privacy, which over the years has produced multiple reports, studies, opinion guidelines on a very wide range of issues, from processing of data in the context of election to facial recognition, processing of health data, AI, processing of children data, etc. And all of that has really, and is really, informing the interpretation, application of data protection rules around the world, and including EU data protection rule, and has also very often led to further development of EU data protection rules. Just to give an example, the Law Enforcement Directive, to a large extent, is based, drew its inspiration from the so-called police recommendation of the Council of Europe. So that's the past. It's a past, but the past that we still part of our present. But I said it's also part of our present because that unique nature of this instrument, unique nature because it's a comprehensive instrument that covers all sectors, all forms of processing. Unique nature because it's a truly international, universal instrument with members and observers from all 5 continents. That, I think, reflects very much what we see today, increasing convergence, on a number of data protection principles, requirements, governance model, enforcement model, and it's also something that shows that these principles, these requirements are really universal because they can be adapted, they're flexible enough to be adapted to different systems, different legal systems, because again, in the membership, you have a truly universal membership of Council of Europe that have common law countries, civil law countries, countries with mixed systems, etc. And this convergence matters a lot for us at the European Commission, and is, for instance, at the heart of our work on international data flows. And then, of course, it's an important piece and part of our future, of the future of EU data protection rules, when, and we hope soon indeed, Convention 108 Plus will enter into force, will be ratified by a sufficient number of countries and will enter into force. That, we believe, will globally bring data protection to the next level. Let me give you an example. Chapter 5 of, not of the GDPR, Chapter 5 of Convention 108 Plus, which deals with enforcement cooperation, mutual assistance. We might want to come back to that later, but that really addresses a real need, fills a real gap at international level. I'm often surprised how data protection, where enforcers, regulators very often deal with the same commercial practices that often affect users in multiple jurisdictions simultaneously, deal, if not with the same companies, that there is actually very little in terms of infrastructure, real infrastructure for data protection authorities to cooperate in individual cases, to exchange information on individual cases. And Convention 108 Plus will bring that to a reinforced network. So all of this explains why, as you know, the Commission, on behalf of the EU, has been very involved in the negotiation of Convention 108 Plus and is a very strong supporter of its ratification and entry into force.
Thank you. Thank you so much. I feel a little bad for the next speaker because it's only 5 a.m. for her. I'm sorry about that, but I have the utmost pleasure to present you Juliana Muller from Brazil, who is the head of international and institutional relations of the Brazilian DPA. She's responsible for international data flows, international cooperation, and the representation of the Brazilian Data Protection Authority in international forums where data protection is discussed, such as Convention 108 Plus. Juliana, the floor is yours.
Thank you so much for inviting me to this panel. Can you hear me well? Okay, so I would like to say that it's a really big privilege to be here, and I will try to touch upon some topics that the organizer of this panel suggested me for today. So, which are 3 topics. So you wanted me to touch upon on why Brazil has decided to be an observer, what benefits and opportunities we see in the convention, and maybe reflections of the topic of this panel, which is which changes this modernization will do in the dynamics of global protection. So on the first topic, so why Brazil has decided to be an observer, it's very easy to answer this question because although LGPD were sanctioned on 2018, ANPD was only created in August in 2020. And by that time, our only option was to enter as an observer because we didn't meet all the criteria of Article 15, Item 5 of the Convention, which requires the DPAs to be an independent control authority. And actually, the good news is that we now can join the convention. I will touch upon this topic in a moment. But we have approved a law in 2022 which transformed ANPD in a special authority with administrative and financial autonomy. So now we can exceed the convention. But by that time, in our early stages, when we couldn't It was a very natural step to try to sit in all the relevant tables where the discussions around data protection were taking place, and the convention was the first of the list because of its unique characteristics that my colleagues have already touched upon. So it's unique. There is no equivalent at global level. It's open. Any country in the world with complying data protection rules can request to accede, an invitation to accede. It's the most relevant and representative forum in data protection. So almost 90 countries, counting with the countries that are bound by the convention and also the observers. It's influential, so it had influenced, like Tamar said, many national legislation are based on its core principles. So Brazil is also one of them, so it makes sense for us to join. It offers, as Bruno said, a practical solution for cooperation on the enforcement of data protection laws. So this is a huge step that the convention is, the modernized convention is taking, and also it will create a transborder data free flow network, which is interest of all of us. So the main benefits, now touching upon the second topic. So the main time, reflecting about the characteristics of the convention makes a little obvious the benefits, but I'll try to explain from the Brazilian perspective the main benefits. So I think, as I said, now we are beginning to discuss about asking to be invited to accede to the convention. And this discussion has already started at the technical level at ANPD and will now involve the relevant stakeholders. But as an observer, of course, we see, and we are being part of this discussion, the bigger benefits I see is understanding the dynamics of the convention and also participating with the discussion with all the high-level experts for these 90 countries who come together to interpret and set worldwide influential standards on data protection every year. So to us, it helps us to converge our data protection system with what the rest of the world is doing. So this is obvious. And also it is a preliminary stage for Brazil to be prepared when it's time to join. So about the advantage that we see to exceeding, actually asking to accede to the modernized convention. So I only see, you asked me about advantages and disadvantages. I only see advantages. The first obvious one is according to Chapter 2 of the convention, which Bruno already touched upon. So in addition to providing pertinent and valuable information, the cooperation objectives can be achieved through coordinated investigations, interventions, and joint actions. So this is a huge step for me. Moving from a bilateral cooperation to a multilateral is a huge transformation, as several countries come together to cooperate on the enforcement on data protection rules, and this is new. This is in the modernized version. The second topic I already touched upon is by facilitating cross-border data flows and harmonizing the rules. We have a single instrument bounding several countries with the same principles and within different jurisdictions. So this can solve many of our interoperability issues on international data transfers. This is also something old and new because we have now new mechanisms on the modernized convention, like the supervision mechanisms on how this, the convention is being applied on the countries. And trust is a very important element on this pillar of data protection, transborder data flows. Speaking a little bit about Brazil, in our legal system, there are specific provisions for international treaties that deal with human rights. So in the case, which is the case of the convention. So in this case, there is a possibility that it is ratified as a right, as a constitutional amendment. So this would confer a character and a status to the convention, an equivalent level of our constitution. And even if this right does not approve as a constitutional amendment, its nature would be of supralegality. So this means that this brings superiority concerning the standard legal order that we have at a material point of view. So we see this as a very positive add to our legal system. So that's why we are reflecting, enjoying it. And additionally, I also see a huge advantage for data subjects, since in Article 18, we see that Brazilian data subjects can ask directly for assistance anywhere within the countries bounded by the convention. Also, we know that Bruno is here. We already discussed this. We see that the accession to the convention is a criterion to be considered in the EU adequacy decision, which EU is very interesting in obtaining. Maybe we can discuss a little bit on this after. And finally, the Convention 108 Plus provides criteria for processing personal data carried out exclusively for purpose of protecting national security, defense, and public service, which is currently a gap in our legislation. So I think the convention may be used as a framework to guide and influence our future legislation on these issues in Brazil. So that's why I think it's very valuable for us to join. And now, the last point, I will be brief, because I think I already answered this in the other two questions. So how the modernization will change the dynamics. So the short answer, two biggest changes that I see, it's by enabling enforcement cooperation and also creating a free flow area for personal data. But of course, we have to talk about trust here, because trust is a vital element on this context. And as I said, the supervision mechanism that is added on the Modernized Convention adds a lot to this pillar, because it's fundamental to everything we do here. So the convention was the first multilateral international instrument that I just mentioned, and the others mentioned as well. And it instilled trust among nations. And many used this principle to shape their own data protection laws. And that's why we are where we are. So the countries trusted the purpose of the convention. And today, it's possible to see how the world has changed from this perspective of data protection. And I think in this new phase of implementation of this special instrument, I think we should now trust, again, the system, trust the cooperative union of countries, and that this will be able to once again produce disruptive results on data protection. Thank you so much, and I will be very happy to answer any questions you may have.
Thank you, Juliana, for this, and thank you for the very great news about the accession. I'm also very grateful for our next speaker for being here on this panel in person. He just landed, so additional personal efforts in this are much appreciated. Thank you so much. Alex Joel from the US. He's a senior project director and resident adjunct professor at the American University, Washington College of Law, where he leads the Privacy Across Border initiative for the Schools Tech Law and Security program. From 2005 and 2018, Mr. Joel served as a civil liberties protection officer for the Office of the Director of National Intelligence. He has a broad experience in national security and also in defense and law enforcement field. Alex, you have the floor.
Thank you, and thank you for including me here. I was here speaking on a panel in 2014, right after, 6 months after the Snowden disclosures, and just a week after President Obama had released Presidential Policy Directive 28 on signals intelligence. So I have vivid memories of that experience, and I'm very happy to be back. I'm glad that you opened by acknowledging or talking about Russia's invasion of Ukraine. From a national security perspective, those are the kinds of threats that people are, that my former colleagues are very focused on. And one of the things that I think is very promising about Convention 108 Plus and the whole process and people have mentioned this already, is how there's a convergence there, not only with different regions of the world and different visions of how you can come together on these issues, but also, as Bruno has mentioned, all forms of processing, which includes national security and law enforcement. So I think all of that is very promising. I would also, just trying to put this in a larger context, as we all know, the US and the European Union have worked out a data privacy framework. There are some more details. That is an area that Bruno, if he wants to talk about, can talk about, but there are more things that need to happen. But that's a landmark, that's a groundbreaking event. So that is a huge step forward in terms of trusted data flows. And there are other discussions and forums going on about how can we have trusted global flows of data when you also have government needs to access that data for national security and law enforcement purposes, and where countries around the world have different legal systems and different ways of approaching these issues. And so we had, coming out of the G7, a mandate for data free flow with trust to operationalize that concept. We had recently an OECD declaration on trusted government access to personal data held by the private sector for national security and law enforcement purposes. So it included the national security and law enforcement perspectives at the table, and I think those principles are very strong and ones that we can and should build on and not lose the momentum for. So we have all of those things going on, and then now we also have Convention 108 Plus. There is an exception, but it's bounded for national security. It has to be necessary, proportionate, with oversight, independent oversight, in Article 11 of Convention 108 Plus. So that's another place where these conversations need to happen and can happen. And it's going to be interesting in terms of what's new in 2024 to see how all these different conversations come together, hopefully to come up with, to use Bruno's phrase, more convergence, like evidence of how we are all coming together on these really critical issues so that we can have a trust in each other's systems in terms of how governments access data, how the commercial entities use that data, process that data, in a way that brings the world closer together and doesn't have us all retreating into our own corners and raising barriers to each other. So I'm happy to get into some more question and answer in terms of what the US perspective is on the convention itself. I am not in government, so I'm speaking not as a government representative, but as someone who can remember what it was like to be in their shoes. So I have some insights on that.
Thank you. Thank you so much, Alex. So we are going to go in the second part of this panel where I prepared some questions for our speakers, which I will ask them and kindly invite them to reply in 2 minutes if they can for the questions. And then we will open the floor for questions from the audience. So be prepared for that as well. So maybe I first turn to Juliana. Juliana, you mentioned a lot of things about Convention 108 Plus, how Brazil is looking into Convention 108 Plus. But as one of the biggest countries in Latin America, do you think you and your country will be in support for growing membership of Convention 108 Plus? And not also from Latin America, but also from Portuguese-speaking networks. As you may know, we are at the convention, at the Secretariat, big fan of networks, of data protection authorities. I know that you are an active network of Portuguese-speaking data protection authorities network. I know that some countries have expressed interest, but how do you see this process happening, and what do you think Brazil's role and your authority's role in all that? Thank you.
Thank you for this question. This is a very good one. Yes, of course, this discussion about acceding to the convention is happening everywhere, including in Brazil, as I mentioned in my presentation. And of course, for us, for our perspective, the more countries join the convention, the best for not only Brazil, but all the countries that will be bound by the convention. So we must work for that. And once Brazil is already a member, we will be very happy to try to influence other member states that we can, that maybe we are closer about because of culture and because of language. We will be very happy to lead this discussion in the other forums that we are participating. Maybe we can begin this discussion now, but we will be more comfortable in defending once we are already a member, and we'll be very happy to do so.
Thank you so much. Now I'm turning to Bruno. Bruno, European Commission had a communication from 2017, which I read with great interest and with many thanks, by the way, where European Commission officially declared that it has an intention to propose to the European Union as an international organization to join Convention 108 Plus once it enters into force. We also have heard, and I'm sure you are also aware, that at the Reykjavik summit, the head of states also discussed the accession of the European Union to the ECHR, the European Convention on Human Rights. Of course, it's a long process, and I don't know if there is any relevance or that can be delivered separately or carried out separately, but what would be your position on that? Is this still on the agenda? How this would change? How do you see your role in becoming party to Convention 108, speaking for 27 member states, if I'm not mistaken, that will be your role?
Sure. So the short answer is yes. Meaning, this is something we have negotiated to be included in Convention 108 Plus, the possibility for us to accede as European Union, as we are member of other international or parties to other international conventions. It simply makes sense because already today, we, to a very large extent, represent the 27 member states because data protection has become an exclusive competence of the EU. So it's a natural, I would say, a natural result of the evolution of EU law. It also makes sense for all the reasons I have recalled briefly. It's a separate exercise than accession to the ECHR, which is indeed a complex process, but where there is now light at the end of the tunnel. And indeed, it was very much stressed at the Reykjavik summit as something which remains a very important objective for us. So yes, we are certainly very interested in that. And again, because it's about being around the table of what I call the only international standard-setting mechanism in the area of privacy. And I think actually that the entry into force of Convention 108 Plus, that we all hope will happen next year, will stress even more at a time when there is an increasing demand for common rules of the game and common rules of the game across the board, because data needs to move. Data needs to move between sectors, between industries, between countries. When there is such a really need for common rules of the game, I think that the entry into force of Convention 108 Plus will probably lead to new accessions to the party, a renewed interest for that instrument. So we certainly want to be part of that, I think, bright future of the instrument.
Thank you. Thanks so much, Bruno. Once high-level U.S. officials told me U.S. will never join Convention 108. Alex, I'm thoroughly enjoying that you are long-term U.S. government officials, but are not speaking on behalf of the U.S. government. So what would be your views, your opinion, your prognosis? Will ever U.S. join Convention 108 Plus? And if yes, what do you think which would be the steps to go through to achieve this? And if not, what other areas you think that would be of interest for more enhanced cooperation?
So again, I am not speaking on behalf of the government of the United States, and I'm not sure who told you that and what they meant by that. But So just a couple, if I'm going to put on my, let me just put on my former government hat for a second and try to put myself in the shoes of a government official looking at this convention. One fundamental challenge is that the United States did not participate in drafting the convention. So as we all know, as you know, as everybody here knows, when you draft an instrument like that, it's a very painful process, a painstaking process. Every word matters. And the United States, for whatever reason, and I don't know what the reasons were, was not at the table negotiating that. So when they look at the document, they say, well, this isn't our document, and I'm looking at it, and this term doesn't sound familiar to me, this sentence doesn't work. So there's that challenge that goes along with it. And that's not to say that they wouldn't take a serious interest in looking at that, and I think if I'm in the government and I'm thinking, should we do this? Like what we would have to go through that painstaking analysis. Are there opportunities to clarify? Are there opportunities to do something about language that maybe the country now has a problem with? So that would be another question. A third question might be, what is the concrete reason to do this? Not to be overly blunt about it, but is it going to be worth the very large amount of effort? Like what's going to happen with cross-border data flows if the United States does this? Is there something specific that you can then go to the president and say, look, it's really worth us investing a lot of capital in getting this thing done? Because then you'd have to get it ratified, in Congress, and that can be a huge, huge challenge. So there are those challenges. On the plus side, like what would attract them to do something like this? As I have read Convention 108 Plus, it is written from the perspective of it applying to a lot of different legal systems. So already the terminology is one that acknowledges that different legal systems will have different ways of dealing with those concepts. So that's very attractive when looking at that legal instrument. Another one is that it covers all forms of processing. That could be a negative, but it could be a positive. The U.S. has made a lot of changes to try to enhance how it protects privacy as well as national security for people regardless of nationality. And the OECD framework is now, their principles are now done. So to the extent the OECD principles are going to inform what people feel meets the Article 11 standards, that would be another positive, because then that hard work has already been done by the U.S. team. It's an instrument that allows a conversation to happen with more countries around the world, not just between the United States and the European Union member states, or not just between, not just a bilateral kind of conversation, but this is now a multilateral conversation on these issues. So I think there's some positives there. I can't predict whether or not the U.S. would take another strong look at this. I'm sure they would be interested. Well, I'm sure. I'd imagine they'd be interested certainly in having the conversations, participating as an observer. I was just mentioning to Bruno. I mean, I think we're at a really interesting and exciting point on these discussions. We've had two very important landmarks that happened: the data privacy framework, the OECD declaration involving the U.S. active participation from a national security perspective as well as a privacy perspective. So really, really important. And we have to sort of capitalize. I think it's important to capitalize on that, and Convention 108 Plus, I think, can play an interesting role in that. The other thing I'll just mention is convention. I'm coming at this from a national security perspective, but obviously there's the commercial privacy issues. And as we all know, the U.S. doesn't have comprehensive privacy legislation. So another question would be, to what extent is, when we examine the document, would we say, well, the way to meet this is with comprehensive privacy legislation, which we all support, but which Congress has not yet enacted. And we were able to address that with privacy shield principles, through adequacy findings, and you can do it with standard contractual clauses, et cetera, mechanisms that the European Union has developed. I see that there's language that allows for some of that in Convention 108 Plus as well.
Thank you. Thank you so much. So, Tamar, as next vice chair of the committee, we've been working a lot together. So, you know, the ups and downs and also some of the internal affairs and internal issues. Hearing all that, it's all positive, I believe, and it's really reassuring, and I'm much grateful for that. But do you think that people around, or even the COE, the Council of Europe, is capable to deliver the expectation many of us might have towards the convention? And what do you think should be the priority areas for us, for the organization, for the new committee, to deliver all this?
Thank you, Peter. Yes, I believe that we all are capable to meet the expectations, and obviously joining our forces and doing our tasks back home, like at the national level and regionally and internationally. As for the priorities, the discussion now we had, and Alex's contribution, and also what Juliana mentioned, really reaffirmed the importance of the exercise that committee is doing, providing some guidance and interpretations in relation to Article 11 of the convention, which is about those exceptions and that should explain and guide states. And I believe this is very important because the ones who have signed but not yet ratified, probably the most important consideration at the national level and decision making is really how the convention will be applicable in the public sector, including in the area of law enforcement and national security. So more guidance, more clarity, how all that should be implemented, I believe is very important and crucial, and it should be a top priority for the committee. And another area I would also, where I think that the more guidance should be made is in the area of sanctions and remedies, because explanations, even with the country, even in my jurisdiction, Georgia, we have very low sanctions which are not effective, dissuasive, and proportionate. So further guidance, how this, let's say, and we can greatly benefit from the, let's say, practice and policy that is at the EU level. And provide similar, let's say, tools to data protection authorities from the member states of the Convention 108 or Convention 108 Plus. And probably we have also to, as soon as the convention will get in force, will enter into force, provide very clear and transparent guidelines about how this evaluation and follow-up mechanism will work, and in particularly like the principle related to independence of the authorities. This is something where further, let's say, criteria should be very clear, and I believe this will encourage more countries to improve their at national level their data protection legal frameworks and consider accession very seriously and very soon. Thank you.
Thank you. Thank you so much. So with this, I would like to open the floor for questions from the audience. There are two mics to each side of the stairs. So anyone who would wish to ask a question to the panelists, please, this is the moment. Yes? Yeah, just could you...
Thank you. I'm Colin Bennett from the University of Victoria in Canada. I wrote a paper a couple of years ago trying to argue to the Canadian government why it should accede to Convention 108 Plus. And I made some very persuasive arguments which were wholly ignored. But one of the powerful arguments, I think, is that accession protects domestic data protection arrangements, domestic privacy law, against perceived threats that might enter from trade agreements. In other words, provisions in trade agreements, such as on issues of data sovereignty, data residency, such as those in the USMCA. And one of the arguments was that accession, and I don't know whether this might also be a factor in Brazil, would in fact reinforce those domestic privacy and data protection arrangements in those countries. I'd be interested in the panel's comments on that.
Yeah, thank you
Anyone
so much.
who would wish?
I would like to get the paper if you can send it to me.
I'm not sure I fully understood actually the question. What will it protect? Can you just clarify this point?
When certain trade agreements, such as the USMCA, have provisions in there which are really preventing or challenging things like domestic data residency requirements, or challenging certain provisions in data protection frameworks in individual countries. Accession to Convention 108 as an international convention is a way to reinforce those domestic privacy rules.
I think, I cannot speak for, of course, for the US, but I think that today there are ways to balance these different needs. And for instance, as the EU, we have found ways in trade agreements to balance the offensive interests in terms of fighting digital data protectionism, or justified obstacles to data flows on one hand, and protect our regulatory autonomy. Indeed, in the area of data protection, but more generally in the digital area, which means being able to define ourselves what is the appropriate level of protection we want to apply without this being questioned in a trade context. But let's also not forget that, and that could be one of the arguments to join Convention 108 and Convention 108+, it's also a data flows instrument. It has a very powerful provision on a free flow of data with some adaptations, but free flow of data between its members. So that again shows, I think, that the two can go and should go together. That could be for an important point for briefing for the president when there will be indeed federal legislation. Yes.
If I may contribute, absolutely. I would agree that this could be a very powerful, indeed, so one of the considerations to discuss, because I remember back then when I was commissioner, I was with my office reviewing many, let's say, trade agreements and different agreements to ensure that actually the data that will be transferred is adequately protected. And indeed, to be a party of the convention and have a robust data protection legislation really helps not to lower the standards with different agreements. And this is also a powerful tool for the supervisory authorities, data protection authorities, to promote this positive, let's say, changes in those agreements. Because indeed, having a robust data protection framework motivates supervisory authorities to make sure that wherever data travels, it remains adequately protected. And indeed, I would definitely agree with the point you have raised, and thanks for this contribution.
Any other question from the audience? Yes, lady on the right.
Hi, I'm Maria Saluster from the European University Institute. Thank you very much for this discussion. I would like to ask still about how, the Convention 108 is an international instrument, but how it helps really with the GDPR. Because as the speaker from Brazil mentioned, it can help in terms of the adequacy decision, but it doesn't guarantee that the country will actually guarantee that you will have it, because there are other conditions. But in terms of the other instruments in Chapter 5 of the GDPR, does the convention actually make a difference for the companies in those countries that have ratified Convention 108? As I don't currently see that it makes any difference, but maybe I'm missing that, and I would like to hear your comments. Thank you.
Well, I think it makes a difference, and Convention 108 Plus, when it will enter into force, will, I think, make a bigger difference than today. Why is that? Because although the convention, of course, is a convention, it's not a detailed legislation. So it is based on rather high-level principles, but which, and that's why we have also played such an important, I think, role in its negotiation, are very much aligned with the GDPR. There will be also a more, because as you know, indeed, for these questions of transfer, we cannot only look at, that's what our Court of Justice, the highest court in Europe, requires, that we don't only look at law on paper, but also law on practice. And here, the committee that will be created in convention will look in much more detail at the practice of the member parties. And all of this will be extremely useful for us to, for instance, in case of an adequacy decision, there's, by the way, a recital in the GDPR that's already recognized that, and to probably fast-track certain adequacy decisions. It's not a necessary element. You don't need to be a party to Convention 108 or Convention 108 Plus to be recognized as adequate, but I think it's a very important facilitator. I see this also in the renewal, you know, that we are evaluating the adequacy decision, and some of them are very old, that were adopted under the previous framework, the 1995 directive. We take very much into account the fact that certain of those countries, in the meantime, have ratified joint Convention 108, and some of them have already ratified Convention 108 Plus. I'm thinking to speak about non-European countries, of countries like Argentina and Uruguay. And then I also see, and this goes very much to what you were saying, Alex, that convention, in the context of Convention 108, there's a increasing interest in developing compliance tools, including transfer tools. And for instance, the committee is right now developing model clauses that from what I see, what is being developed, share really a lot of commonalities with the ones we have in the EU, the ones that have been developed in Latin America, the ones that have been developed in ASEAN, the Association of Southeast Asian Country. There's a panel on this later today, I think. So no, I see actually a lot of not only of commonalities, but a lot of common work. The fact that there will be also a network of authorities, I think they will, we will see more and more work between networks, the EDPB, the one of Convention 108, the African one, the Latin American one, that will come. And I think there's, when people work together, they tend to find solutions. And when they work together with effective powers, they tend to find effective solutions. So no, I think this is a very important development. And then let's not forget, last but not the least, you were mentioning, of course, the specific requirements we have on the EU law. The fact that Convention 108 Plus covers all sectors, including national security and law enforcement, with no possibility of reservation, contrary to the case under the current version of the convention, is for us a very important aspect, and again something that might make it easier and faster to find essential equivalence. But yes, you're right, they need to be a specific EU assessment, and that will have to be done on a case-by-case basis. But again, I think that accession to Convention 108 Plus can really significantly facilitate that assessment.
I think it's very interesting. So the U.S. is perhaps in a unique position of having had adequacy decisions go all the way up to the Court of Justice twice, and probably going to be a third time. So I still have to think further how. So Bruno, you're obviously the expert on this, but the thought that's going through my mind is, yes, it will inform. It's, as you said, it would inform the European Commission's adequacy decisions. It would be very helpful, very influential. What role would that play in litigation that ends up before the Court of Justice? Are they going to find it? My gut reaction is yes, right? That the more those kinds of legal instruments would be persuasive.
I think that yes. Again, I cannot speculate on what the Court of Justice might say on a specific case concerning a specific system, but the fact that those are international commitments that therefore beyond domestic law create another layer of obligations and international responsibility also attached to this obligation, I think is something that can have a weight, yes.
Thank you. While other questions are being prepared, we still have some time, so I maybe also bounce on some of the issue you mentioned, corporations or companies. As you may know, international conventions are for countries, for state parties, and for Convention 108, it also goes for international organization, very luckily so. But what about companies? A lot of attentions are turned to companies that are processing personal data. Some of them are bigger in terms of volume and also in terms of revenue than our member states. What should be the role for companies in the whole process? And all this, the Secretary General of the Council of Europe, I think 5 years ago, recognized this real opportunity to work on a multi-stakeholder model and include, first conclude MOUs with large internet companies to work together on policy issues of common interest. And of course, privacy is one of them. And it would not be very appropriate for me to reveal some of the difficulties we have been having on privacy issues with the committee and with the Secretariat engaging with companies. But what would be the panel's views on that? So what should be the role, or should there be any role for companies in accession processes, in implementing Convention 108, maybe Alex, for you, for national security issues, what could they gain from the whole process? Juliana, you also worked in a large company in your country. So have you heard about Convention 108 at all when you're working there? Or have you thought about all these things when devising privacy policy? Or do you think one should look into that, or what should gain from all that? And Tamar, you have been engaging also with lots of companies, I believe, while you were data commissioner. So is there any space for that? And if so, how should we start negotiating with that? And of course, Bruno, I would be very interested in your views as well on involvement of companies and multi-stakeholder actors. Oh yeah, so I don't have a particular order, so maybe Juliana, yes.
Okay, thank you. Thank you so much for this question. It's a very good one. I will give only my humble opinion. I think in the digital world that we are living on, this concept of national borders and also traditional sovereignty has to be revised and is being revised, and we'll have to adapt to the real challenges that we face. So for the example that you mentioned, we have a big corporation that are everywhere, or maybe different companies that are spread into the world, but they have their operations intercombined. So it's not possible to think on national borders anymore. So for me, the real solution for this, I really believe this, is to ensure effective data protection countries. We must strive to form a common regulatory space. And in my view, it should be guided for the principles of Convention 108+. So we have to think on a global solution, and maybe the convention is the best start that we have to this point, to the point that we are. And maybe, of course, we have to start discussing how and to what extent we have to detail this treaty in order for it to be enough and to be sufficient to regulate all this common space that came with the internet and the digital world and the new reality that we face. So that would be my first comment on this question.
Alex, maybe?
Yeah, so my most recent experience that's relevant, I think, here is with the OECD, and they have stakeholder groups, and they have the business group, and they have civil society and other groups that they consult with, and I think that's really important to do. As Juliana said, we're living in a digital world, and all the devices that people have here, everything we rely on is provided by companies. Governments aren't in a position to do that. So if the companies aren't going to do it, it's not going to be there, right? So we're going to have a private sector that is increasingly, or has already, is the point that gives us all of these communications capabilities and processing capabilities. So there has to be some conversation with them and some ability to understand what they want and what is going to be, helpful or problematic. Not that you have to do what they want, but it's just an important information point. The other thing I'll say in terms of what they want, just to switch hats, and if I'm going to put on a private sector hat, it would be certainty, right? So they would want certainty. They would want to know what are the rules, and then I can figure out how to, and the ability, rules that they have the ability to comply with, not rules that, obviously if the government has to do it, then the governments have to do it. The companies can't do it. So they want certainty and rules that they can comply with. And I don't think those are unreasonable. We just have to work through how to provide that.
Just to say, of course, this is a convention, so it's first of all addressed to its parties, which then have to translate its requirements into national legislation, but which at the end has to be complied essentially, not only because the public sector is also involved by companies. So what I think is really important, and I'm very happy to see that this is happening, is that indeed the committee starts developing compliance tools, because that's a tangible way to raise awareness, support about the convention, its rules, supports the culture, privacy culture on which this convention is based, and give tangible assistance to companies or other actors in terms of compliance. So the ongoing work, for instance, on model clauses, I think it's the first time, if I'm not wrong, that the committee engages in that type of work, which actually is going very well, I think. And that's a very positive sign, and that we would certainly encourage to also develop that type of work. And again, the new dimension that Convention 108 Plus will bring in terms of cooperation, mutual assistance between data protection authorities will probably further facilitate and in a certain sense legitimize the role of the committee also for that type of work.
Tamar?
Just a few additions. Actually, at the committee level, I can recall the discussions on particular guidelines, for example, on health, where the business associations and private sector was very active in terms of the consultation. This, I'm sure, will continue. And then, obviously, the private and plus, we also developed certain guidelines, for example, I can recall on AI, which specifically addressed also the private sectors, because we know that many those systems are developed by private actors. So the part of the guidelines was addressed to government, then the decision makers, and then to the private sectors as developers or decision makers. So there are certainly the positive experiences, but I believe that the, let's say, awareness on the benefits of the convention and convergence and what, let's say, additional instruments will bring to private sector, we have to further promote that. Probably the level of their understanding of those benefits not at the stage as we wish, but I believe that this is the absolutely right opportunity to further explore and engage and collaborate, because obviously even like if beyond the committee will take the recommendations of the Council of Europe ministers, right? Obviously, there are recommendations that directly address to particular states. They call for certain actions, and indeed the private sector has an interest because those recommendations and those suggestions affect their daily operations, and indeed the opportunity to engage, to participate, to share and their views. This is something that should definitely continue.
Thank you so much. If there's no other questions, I don't see any from the audience. So finally, I invite you to applaud our wonderful panelists. I have been enjoying this a lot. I hope this is the same for you. Committee of Convention 108 is an open committee. You can follow all of our work online and participate if you wish. Thank you so much. Thank you for all of you being here. Thank you so much. And I really believe that in 2025 we will start with a big celebration. Thank you.